Public Notice of Non-Compliance, Non-Assumpsit, and Counterclaim. October 12, 2020 by Anna von Reitz. To all parties and principals concerned, notice to agents is notice to principals, and notice to principals is notice to agents. Although we informally call the United States of America, the United States, that isn't really what the United States is. The entity formerly known as the United States was originally the unincorporated government of the Union of States formed in 1776. In 1790 this entity began using the proper name, the United States, and its municipal power-sharing partner began operating as the United States. So, in fact, the United States, today is the municipal government of the District of Columbia, and it is limited to the 1 mile square, devoted to the Municipality of Washington, D.C. This entity continued to operate as an unincorporated business from 1790 to 1878, when it was fully incorporated as a municipal corporation and recognized as an independent international city-state, run as a plenary oligarchy, by the members of Congress, allowed under Article 1, Section 8, Clause 17. Now read the Birthright Citizenship Act of 2017 Abstract, Birthright Citizenship Act of 2017. This bill amends the Immigration and Nationality Act to consider a person born in the United States, subject to the jurisdiction of the United States for citizenship at birth purposes if the person is born in the United States of parents, one of whom is 1. A U.S. citizen or national, 2. A lawful permanent resident alien whose residence is in the United States, or 3. An alien performing active service in the U.S. Armed Forces. The Municipal Government DBA, the United States, is claiming that babies born to all federal civil service employees, to people born in the insular states and possessions, to political asylum seekers, and to Americans serving in the U.S. Armed Forces, are subject to the jurisdiction of the United States municipal government and are citizens of the municipal United States government at birth. Slaves, in other words. Public slave ownership has never been outlawed by the United States, and so it continues and grows and thrives. This time, they've attacked and attached the children of innocent American servicemen and civil servants. They have also set up a verbal conundrum by which they may hope to claim that any American they see as a lawful permanent resident alien, a form of political asylum seeker, obligated to serve the municipal oligarchy, if that alien, from their perspective, resides in the United States. Welcome to Little Rome. The problem is that the Constitution of the United States strictly limits their government to the 1 mile square set aside for them in the District of Columbia, and their apparent gross overreach and usurpation in forming over 185,000 municipal corporations and claiming millions of acres of land in this country as federal land owned and operated by municipal corporations, is both illegal and unlawful and a gross international breach of trust in violation of our treaties with their government, in violation of their own law as adopted via the Geneva and Hague Conventions, and in violation of the Nuremberg Code. So is any claim that the people living on this illegally and unlawfully purloined land are citizens of the United States, and assets belonging to the municipal United States government in any form. We firmly return and refuse all such claims of conferred citizenship obligations, together with all interpretations and all presumptions leading to the conscription or trafficking of any American into municipal jurisdiction. The state citizens, known as the people of this country, who are principals and parties to the Constitution of the United States, issue this notice of non-compliance, non-assumpsit, and counterclaim to the municipal United States, their bankruptcy trustees, and all other principals and concerned parties. We demand that the 185,000 plus illegally and unlawfully and immorally established municipal corporation franchises be dissolved, and further demand that all assets purloined in this process be repatriated to the United States of America and to the states and people to whom these assets manifestly belong. We also demand that all abuse of usufruct privileges immediately and permanently stop, and that all so-called individual municipal corporations gifted to Americans in their own names as a means of constructive fraud against them be dissolved. All profits, fees, leases, tithes, beneficial contracts, stocks, bonds, titles, copyrights, patents, trademarks, material and immaterial assets, including houses, land, and public interests including our court buildings, roads, railroads, public utilities, parks, and national defense investments must be returned to the victims of these heinous false claims in commerce and attendant abuses. We also bring your combined attentions to the filing and approval of yet another incorporation charter in violation of our trademarks and good name. United States Limited, Fairways House, George Street, Manchester, Prestwich, England, M259WS. Company number 12,666,306. Status: active. Date of incorporation: the 6th of December 2020. Country of origin: United Kingdom. Company type: private limited company. Nature of business: SIC tax consultancy. We fail to see why any government under contract to us to provide us with good faith government services should be operating a municipal corporation in our name, nor why any government principal should be issuing an incorporation charter to any private limited company in our name. This is an unconscionable infringement upon our identity as a nation and an invitation to constructive fraud which is entirely unacceptable to us. Please promptly notify the appropriate parties to rescind approval of this charter application and make appropriate adjustments to ensure that no further infringements occur. Signed by Anna Maria Riesinger, Fiduciary, the United States of America.